think introduction slide is already there, so I don't know whether I really require to introduce, and these all are well-known faces in various seminars. But having said that, still, you can introduce yourself. That's best way of introducing.
Hi, I'm Shantanu Mukherjee, legal head of Asia Pacific and Japan for Lupin.
Hi, I'm Ronabir Basu. I'm the Regional General Counsel for Dr. Reddy's. I started my career in Unilever, then moved on to Sandoz. The last 10 years I was in GSK, and now I'm with Dr. Reddy's.
Hi, I'm Ashish Chandra. Most recently, I was the Group General Counsel and Tech Head of Snapdeal.com. I have been mainly into consumer internet and the TMT sector over the last 17 years. It's a pleasure to be here.
I'm Kanaya Thakkar, General Counsel of Ambuja Cement, which is part of the Lafarge Holcim Group now. Well, subject today is, as we know, compliance and governance and regulatory changes. Now, compliance is a basically umbrella term, as we know, and 1 hour time to speak on compliance itself is very, very short time. So we would like to cover basically at a macro level, culture, mindset, and behavioral. These 3 aspects of compliance segment in our entire legal gamut of responsibility of GC and compliance officer. And in this context, I'll be trying to ask questions to my panelists who are expert in their own industry. And we have an opportunity today to have a diversified expertise. A couple of guys coming from pharmaceutical, and this guy from e-commerce, and I am from commodity. So we'll try to cover up more of a kind of a journey from compliance and compliance culture and expectation of compliance in Indian context versus MNC of last 1 decade journey which we are crossing, and we are witnessing this journey. So I would like to ask, start with you, Shantanu, about pharmaceutical industry. Is, according to your view, compliance is just a tick box exercise which Indian organizations were at some point of time, and it's just kind of a formality? Is that a situation now also, or you really think or feel that it's kind of bread and butter for your industry?
Sure, thanks, Kanaya. It's good to be here. Thanks for having me here, everyone. I think the pharmaceutical industry today is a good case study for realizing how compliance can destroy your industry if you don't take it seriously enough when you're playing in regulated markets. Now, my esteemed panelists will, I'm sure, speak later about how compliance is generally perceived in India and the culture and tone of the top and all of that. But I'd just like to make the point now that when you're functioning in a regulated economy, an economy that takes its compliance very seriously, then you perforce you have to take compliance very seriously. Let's start with, in the pharmaceutical industry, FDA. If you don't comply with good manufacturing practices, if the FDA comes and inspects your plans and finds, God forbid, that one of your engineers isn't wearing gloves, the media picks it up in 30 seconds flat. The next day, it's on CNBC TV 18, your stock falls 25%. Shareholder sort of value is eroded instantaneously. Your credibility drops, you get re-rated the next minute, and it affects business in a much more tangible way because your entire pipeline that you're planning through that manufacturing plant then is suddenly backed up. So that fancy new oncology drug that you're planning on launching in the US the next quarter, guess what? That's not going to happen. You either go through the remediation process and fix the problems that the FDA has identified, or you move manufacturing of that oncology product to another plant altogether, which is best case scenario, a 3 to 6 month process. Best case, this is if your processes and systems are super efficient. So there are very real implications to not being compliant in the pharmaceutical industry. And the reason for that, I just want to distinguish this from functioning purely in a domestic environment, right? This is where Ronavir and myself work for Indian companies that derive the majority of the revenues from overseas, right? From regulated markets. Americas, Europe, these guys are huge in Russia. We derive almost 51% of our revenues from the US. So, these are countries that take certain aspects, compliance in general, and certain aspects of pharmaceutical compliance extremely seriously. We talked about the FDA, the regulations. Let's talk about FCPA for a minute, right? Now, the FCPA doesn't really apply to Indian companies. Why then am I so worried about it? Why then is Ronavir worried about it, right? It's because you can't function today at a global level at any meaningful as a meaningful player in the international pharmaceutical space without doing business with American corporations. And American corporations are mandated by the FCPA, which applies to them, to have a clause in their contracts that the guys they're doing business with comply with the FCPA as well. So it bleeds through, right? So this culture of compliance must necessarily bleed through these contracts into our companies. So that's how you land up in a position where if you're not FCPA compliant in a particular country, and that country may otherwise have no connection with the US at all, if you're not FCPA compliant, then you will not get in-licensing deals. You will not be able to grow your portfolio. You will not be able to even do business, say, with a distributor or a supplier in that territory because you can't say that you're FCPA compliant. And the FCPA, I mean, everybody knows by now, is no joke, right? $800 million is what, who was it? Siemens, I think. Siemens, $800 million for not following the books and processes, the books and records provisions. Teva, about $526 million they got fined. GSK got fined $20 million in China. So pharmaceutical companies have not had an easy run of it because the way business has traditionally been done by pharmaceutical companies has sometimes, shall we say, skirted the edge of good practices. And that increasingly, with the DOJ and the SEC taking a very, very strict view of these things, that increasingly is no longer acceptable. And we're talking about huge fines, right? So again, the Siemens obviously wasn't a healthcare related thing, but Teva has paid 526. That puts Teva on the 4th largest fine payer on the DOJ's list.
To summarize your viewpoint, Shantanu, you required to comply various license approvals from business perspective, and that's why it's become a must-do kind of exercise. While dealing with this kind of issues in your industry or in your company, how have you understood this mindset difference between Western world versus Indian organizations? And is it just because that you're required to do for your business, you're required to compliance? Or it's kind of, and then implementation of compliances. As a compliance officer or as a GC, you think that time has come in an organization to demonstrate clear-cut responsibility of execution of the compliance is different, and then developing the mechanism for compliance is advising, guiding, and facilitating is different. Because I have come across a situation in various organizations in India wherein compliance officer is then expected to do everything. If you are advising to do comply certain law, you have to do. But I have a different view here that it's not you have to do as a compliance officer. It is a business, it's an operational in-charge unit head who has to execute these compliances. So is it a mindset difference or it is a maturity level difference here?
I think my other panelists will speak to some of the other issues, but I just wanted to say yes, absolutely. And maybe I should just emphasize by saying that no, it's not just a question of mindset, it's a question of looking at compliance as essential for the survival of your business. You need to start thinking of compliance not as a tick the box, as you said rightly, or even as a question of adhering to law, but rather, I need to do this or my business will not last this cycle. I will lose competitive position, I will lose strategic advantages, I will lose market share, and eventually I may not have a business at all. That is, I can tell you, the way Indian pharmaceutical companies, that's the way of thinking that Indian pharmaceutical companies are slowly coming around to. And I believe as more and more Indian companies start doing business, well, start doing meaningful business overseas, they will come around to the same way of thinking. Because overseas, again, it's not so much about thinking, mindset and all of that, it's a simple matter of enforcement, right? The DOJ and the SEC enforces the FCPA and they enforce it aggressively across boundaries. We still haven't gotten there in India, no matter how many times the Prime Minister and other authorities stand up and say that, oh, we'll bring down the price of this, or we'll take action against corrupt doctors. Nothing really gets done, but things get done overseas. So when you're doing business overseas, you start taking things a lot more seriously.
Okay. So my next question is to Ranbir, who happens to be from the same.
Yeah, just before you go into
Sure.
the question,
Yeah.
I'm happy to take the next question.
Sure.
So just to add to my colleague Shantanu, I think when you talk about compliance in general, we all know the importance of compliance. I think speaking with respect to Dr. Reddy's example, very recently, Shantanu, you mentioned the impact which it can have on the share price. US FDA had audited a couple of sites of Dr. Reddy's, and there was a direct impact as soon as the observations of the US FDA were out. So very, very important.
I lost a lot of money on that stock.
Well, you can make it up now because it's back up again, and they followed up with remedial actions. Now, I was talking to John before we started the session, and I think when we talk about a compliance framework, it's very important to understand your jurisdiction and your regulator as well. In India, regulators are not given the luxury of any kind of discretion. The law is there. They look at it as very black and white. However, having had the opportunity to work in a very, very regulated market like, say, UK, and along with my other colleagues in the US, the mindset of a regulator is very different there. So if there is a violation, it could be a small violation, technical violation, or a grave violation. The mindset there is, tell me if you've gone wrong, tell me what you're going to do to correct it, and then let me know once you have corrected. Well, here, I mean, the challenge is obviously very different because if it is a violation, automatically the regulators are forced, to almost go in for criminal prosecution where the law permits them to. So it's very important to understand, the jurisdiction and what a regulator can and cannot do also in that market.
Correct. I think that's what my question.
I should just add on to that.
Difference in the country versus India versus other. And, in India, we have a culture of putting everything under the carpet. That's also a thing that if there is a non-compliances, there is no mechanism also, and there is no clear mindset also that you go voluntarily to authorities and disclose that, look, this is non-compliances. Reason, as you rightly said, because of extreme steps like prosecutions. So that's also not good. And versus in UK and other countries, you are saying it's enabling regulatory authorities for compliances.
That's right. I mean, what the regulators, look, even from a regulator's perspective, what we have to understand is they also have limited resources. They can't go around, in enforcing and prosecuting every company. There will be technical violations. And I think when you're talking about, I was attending another seminar 2 months back, and this was with respect to enforcement of FCPA. The person who was delivering the lecture, he was a former FCPA enforcer. And he also said that, look, just from resources point of view, it is not possible for the regulators, the SEC, to go after every single violation. So what we try and monitor as much as we can, but then we really go after those who have really bent the system. But otherwise, the intention, the very clear message to the companies and the industry is, if you've gone wrong, our interest is not necessarily to prosecute you, but to make sure you get it right back again.
And if I can just add a solid point right there, and not only do they exercise discretion in terms of deciding who to pursue, but also once they have initiated an investigation, they will reduce the amount of monetary penalties if they find that you're cooperating. They will reduce the amount of, Teva, for example, I think Teva's fine, it ended up at 526 million or something, but it was actually reduced because they felt that remediation measures had been taken since 2013, which is when the FCPA violations were found. The award was handed down in December 2016. But they found that in that period, all of the people who were involved in the acts of bribery in question had been removed, and that new systems and processes had been put in place. The same thing, to a certain extent, has happened with other investigations outside the pharmaceutical industry, where it is found, and in certain cases, the FCPA will even reduce their finding to saying, will reduce the investigation after it's been initiated and say this was an act, this was a rogue act. So this was a rogue trader, this was not an institutional problem. So this is an important thing for companies to understand if you're operating overseas, because what it means is, okay, the implication of that is that if you have systems and processes in place and you can show that you have conducted training sessions and so on and so forth, and you have regular follow-ups, and you have ways and your books and records, right? Many people forget this, but half of the FCPA violations are actually on the basis of not keeping books and records accurately, not actually on the basis of bribery. So if you can show that you've kept books and records carefully as required on the FCPA, you may find that even if an investigation is initiated, your fine will be substantially reduced, or perhaps you can even get away with an argument that this was a rogue act.
Just to add on and supplement both of your views, today morning I was just reading one report of Deloitte, a recent report on compliance trend in India, and very surprising data coming across today with us is whether Chief Compliance Officer has a seat on a senior management level, board level. Answer is yes. And percentage comparison with the global versus India is same. Whether we have an authority as a Chief Compliance Officer for driving the compliance in organizations, again, we are near to the global trend. But the one area, which we are, two areas rather, which we are drastically lagging behind is surprisingly compliance training. When, as a Chief Compliance Officer, we must admit that when we have the authority, we have the responsibility also. And in India, we are 60% below the global trend about compliance and awareness and educating trainings to our internal clients. This is data which in a survey report. And this is also, when I was reading this, it's a personal experience from my own organization myself, that more you provide the training, more awareness, more engagement of your business operations guy in various functions, it creates a lot of benefit in basically. I'll tell you one thing. Compliance trainings and educations to your internal clients has a two benefit. And one benefit is direct benefit that non-compliance will reduce. But second benefit also, which is not intended to achieve it, still you are achieving, is even the guy who want to non-comply because of the business compulsions or because of shortcuts method or mindset or behavioral or cost impact or whatever you say, at least he has an education that how to handle the situation at the ground level. If he does this way, he will caught. If he does this way, he will not caught. So there is an unintentional education even to break a law as well when you're providing training, which is not an intentional, which has not been warranted. But these two benefits you always get, which I think is a need of our organization and Indian organizations specifically, including, of course, MNCs in India or Indian MNCs in both scenario. So this is one aspect. And third and last is, lagging behind is, engagement of compliance officer and responsibility in each function for compliances versus engagement of the business operation. There also we are lagging behind drastically in a global trend. Unit heads, operational heads, their engagement and their responsibility towards compliance is more in a global trend versus India. So these two differential deviation of trend reveals one fact that we are good in the policies, we are good in the lawmaking, but we are poor in enforcement, we are poor in implementations and executions. Of course, having said that, we are catching up that trend. So in that context, if anything from, yeah, you want to say something?
Thanks, Kanaya. So I think, again, companies know about the importance of compliance. We have enough precedents to show if you're not compliant, what can go wrong. I think because there are so many lawyers in the room, one thing which probably many of you all will identify with is when you look at compliance and legal coming out with policies and frameworks and stuff, we are looked at as police, okay? And very often, very often we hear, the email is sent out, this is the name, this is the new SOP or the policy, and the business reaction is, oh, for God's sake, another policy, okay? So I think, how do we make it, how do we ensure that absorption of that policy or the framework which we are trying to put in place is well received? And this is where I remember I had read a quotation which says, tell me about something and I will forget. Show me and I might remember. But involve me and I may contribute.
Engagement.
And that is where I think, when I read that, I really realized that as, in the pharma industry, there was, there is this regulation which you may have heard of. It's called UCPMP, Uniform Code of Pharmaceutical and Marketing Practices. Very heavily debated regulation. And all the business really wants to grow their business. They want to, you see their numbers going up. And the more training you give on this, you see resistance. Because they see, well, what are you doing to enable the business? We know all this. So I remember we had tried an experiment, and where we were implementing a new policy. What we had done is legal, compliance, medical, and the necessary stakeholders. We studied the law, we framed it, okay? So the first objective was any policy which we are making is try and make it easy and communicable for the business. Because very often we write these things and it gives us a lot of clarity, but we don't know how it is received by the business. So when we framed that, what we did is we got one of our business people into the room and we tested out to see whether he can understand what we've said and whether he believes and whether we could convince him, being from the business, that yes, the new framework which we are putting in place is correct. And once we convinced him, the compliance training was actually given by the business.
So I got a point. So basically you're trying to say that compliance officers should behave like the business partner and not like the police officer in organizations.
That's right.
Having covered this traditional industry of pharmaceutical, new challenge before us is today digitalizations, data, and different virtual world which we are living today is e-commerce and various applications and platforms, and where I think Ashish would like to throw more focus on that. What are the challenges we have going forward too? And we talked always, when we talk about compliance, we talk about FCP, we talk about anti-bribery, anti-competitive, these, and very existing compliance model. But there is a new challenges which Ashish, I think, would like to focus more for digitalized world and e-commerce business.
Thanks. I think the most important part when we, work with a disruptive industry, I won't be focusing only on the e-commerce or maybe the payment gateway businesses, because I would be focusing more in terms of consumer internet disruptive businesses. The first part is that, when you as a compliance chief or as a general counsel, you work with the promoters or the CEOs who are like early 20s, right? Who are like, completely passionate about growing the business, and they have loads of pressure from the investors to really show them, skyrocket growth. So I think that is something which is a very important mindset which you as a compliance officer or as a general counsel need to internalize, that who are your clients, who you have to work with when you have to promote a culture of compliances. I think the other most important part when it comes to about designing of compliances or strategizing of the compliances, if you compare the consumer internet industry versus the brick and mortar, which is more traditional, for the brick and mortar, the compliances are more internal because you have the set of rules and the laws which have been adequately made, addressed, interpreted for so many years. You just have to tick mark or have to preemptively prepare your organization. In the consumer internet industry, which is more disruptive, you don't have adequate law to address your business model, you know, whether it is e-commerce, whether it is a taxi aggregator business, whether it is mobile wallet, whether it is OTT, your video business, so on and so forth, right? So in that case, the role of the chief compliance officer or general counsel becomes more external, in the sense that you actually become the spokesperson or the ambassador of your company's business model towards the regulator. You actually go meet them, engage with them, educate them about your business model, so that appropriate compliances or appropriate law can be framed to facilitate the growth of business model. I'll just give you a few examples which I personally was involved in actually shaping up some of the critical laws in India which talk about consumer internet industry. My first thing was sometime in the year 2006 or 7, when I used to work as a legal counsel with eBay. At that point of time, the erstwhile acquiring company of eBay, Bazi, had faced some problem with the law enforcement, wherein some third-party seller uploaded a porn clip on their e-commerce website. It was linked to child pornography, and the CEO of the company was in the jail for 3 days, right? And that actually created havoc amongst the international community and the investor community. So at that point of time, why, I mean, he was in jail because one of the things which you said, that a regulator or a law enforcement person has no other way to implement the law but to start a criminal prosecution because of lack of bona fide discretion. And I focus on the word bona fide more than on discretion. So then, we actually did a lot of lobbying efforts and convinced the government to rationalize and make more improvement in the Information Technology Act to provide the safe harbor to most of the consumer internet intermediaries. So I think that step took a good kind of example in India, and it actually provided good ecosystem for disruptive industry which act as intermediary to grow the business without the fear of some sort of third party doing hanky-panky stuff on your platform and your CEO going to jail. The second most recent part was something which was a page 3 news on all the newspaper, was FDI in e-commerce, right? So, it took us a lot to educate the government and the regulators that why FDI should be promoted with some checks and balances in the e-commerce marketplaces, how they are different from a traditional e-commerce retail B2C and your B2B versus C2C retail. And I think they framed good regulations, which is helping now, few of the biggest e-commerce players in India to pump in multi-billion dollars. Other thing which we did was that, we were faced with some kind of an unfortunate criminal prosecution, wherein a third-party seller uploaded prescription medicines or illegal drugs on a marketplace platform, and CEOs and the directors and the CXOs were faced with the criminal prosecutions. Why that happened? Because of lack of the regulations, because law normally don't keep pace with the technical developments in the disruptive industries or the business model. So a non-bona fide discretionary interpretation would always give problem to the companies, right? So what we did is that we handled that case very tactfully, but along with that, we reached out to the various industry association and to the government to say that, look, now if you want to give the benefit of the drugs, availability to the remotest part of the country, you need to make the use of internet. And government heard that, and they then immediately formed a committee, and that committee then issued the draft guidelines for sale of drugs on the online platform. So I'm just saying it's like the role of the chief compliance officer in disruptive industry as far as compliance goes is more external, because you have nothing to comply with, because most of the important regulations are gray. It don't apply to you. So you need to educate the regulators, build ecosystem so that your business can grow. And I think that's the only way Ubers of the world and Googles of the world and Facebook of the world are actually forcing the government to look at making the law in a different way then to help them to actually grow their business?
Ashish's conversations reminds me of a few instances where we talk about FDI in a retail. When I do remember when Walmart case on FCFA ground, out of 5 law officers, 4 law officers were asked to resign. At the same time, our government was talking about FDI and retail. So there is no synchronizations of regulatory changes and preparations in India, in our country, versus global expectation of compliances of the various standards. So one, as you rightly said, that there are certain areas where it's not in your hand. It has just, you have to educate it, correctly mentioned. So there are the 2 challenges. One is gray area within existing law. Other is regulatory changes so fast that as a chief compliance officer or as a CEO, you have to adopt those changes very fast and be preventive actions in a timely manner before you caught into a wrong side. And last but not least, I would like to demonstrate last 5 to 6 years cultural changes in compliances by one small example, which again today morning I was reading that article. One MD of one of companies, hardly 700, 800 crores company MD, was talking to his licensing officer that Mr. Bala, you used to manage all these things in the last 5 years, you never have any problem, and nowadays we are seeing so many so-called notices from various authorities. What's wrong with you? You're not handling your job properly. The reply of the licensing officer to MD is that, boss, it's not possible to manage the authority so easily as in past, because there is a RTI acts are there, bureaucrats are afraid of their job. This kind of bribing and managing the things are becoming political issues, be it MD level or be it licensing officer at a corporate affairs. And we are in India, if you see, we are in a transition position. We're at a transition position because in the US and Europe, if you look at it, lobbying is possible there. Is officially there is allowed to fund to lawmaker and in the parliamentary. You can make your law by your lawyers community or your politicians by officially donating the money and make a law as business friendly as you require. So it's called lobbying concept is there. So when we are copying the Europe and Europe model and US model in India for compliance perspective, we are forgetting the fundamental points in India that lobbying is illegal in India. Today, even if I have the genuine requirement for interpretation, my representation, my industrial lobbying, if I attempt to do that, it will be treated as anti-bribery policy or I'm caught in the wrong side. So when we copy the things from other part of the world to here, we have to see that we have totally copying and not a halfway. It's a very dangerous situation. Be it is a competition law, be it is an anti-bribery policy or FCPA, but then unless until you copy 100% as per suitable to your culture, you are creating disaster situation for your businessmen in India.
So, Kanaya, I'll just say
these
that
are the areas which are burning areas, which I think legal community has to think over that, and I would say legitimately lobbying this thing to the government, though it's illegal lobbying in India.
So I, with all due respect, that lobbying is a taboo in India. I don't think it is illegal. I have first-hand personal experience doing these things over last more than a decade, right? I think, to my mind, lobbying is when you have to do an external communication of your business model, the pains and challenges which your business model faces under the existing legal ecosystem, convincing the government that, look, if you change the law, if you improve the regulations, then how this is going to benefit the industry, how is it going to benefit the employment, how is it going to benefit the GDP, and ultimately how this will also indirectly benefit your vote bank. I think what's illegal is the ways and means in which you lobby. If it involves some sort of kickbacks, if it involves some sort of gratification, some sort of taking out people for international holidays for no purpose, that, yes, it is illegal, but a bona fide lobbying to help the government understand is absolutely legal. I have had personal experiences. I have never faced any prosecution, I have not received any show cause notice. And I was, one of the very, famous guy to walk across DIPP, your corridors when, we were lobbying about FDI in e-commerce. So, and if we do not lobby, trust me, government is not as smart in terms of creating business model as entrepreneurs and as in-house lawyers like we are. I think it is our social responsibility and a professional responsibility to help our government and the lawmakers educate them that what's the right business model and what's the right law for you to improve the ecosystem for the further growth of business model. With all respect.
Good that Ashish, you address this point, and this is exactly the a couple of years back when lobbying concept was been asked to Indian GC that why don't you lobby with the government? The way we read and meaning and interpret the lobby in India and what I'm talking about USA is itself is a different meaning. As I was mentioning that lobbying in USA, you can officially sponsor or give the donation for making a law. That is the lobbying exactly meaning in the USA. While what you are saying, Ashish, is here is that representation to the government for the genuine requirement through trade associations and like that. And here, that we are calling is lobbying. So the lobbying itself is a different meaning in that context. So yes, but having said that, one more area which I would like to touch upon here, that this is again culture in India. Indian industry entrepreneurs would like to react to the situation after completion of the law passed, rather than engaging with the government when the law is in process of making. For example, government is always gives opportunity to legal community or industrialists to represent their views when the bill is in process and all. But we hardly represent that things. We are at, okay, dekha jayega jab act aega tab. Then after passing the act, there is always interpretation issue. There is a loopholes, unintentional interpretation issues, and then we go to the litigations. So in various trade association body, I have mentioned that wherever there is an opportunity, when law is in process of making, please engage, represent yourself, and try to educate the government officers that this, if you pass this way, there will be loopholes like this. Rather than reacting to the law, react to the bill and law processing activity.
And,
So
just as
any point, yeah.
Sorry, thank you.
Yeah,
I just wanted to make a funny aside about how lobbying sometimes turns out. So for years, generic drug manufacturers used to lobbied the FDA in the US to increase their resources so that generic drugs could be approved at a faster pace. This eventually led to the passing of the GDUFA, the Generic Drug User Fee Act, which essentially said to the generic drug manufacturers, pay and receive a speedy, passage of your clearance. Not pay in the sense that pay me under the table, but pay a certain fee and generic drug processing your application, your ANDA will be processed quickly. Now, the FDA used the resources that the generic drug companies paid them over the years to bolster their investigative bench strength, and now those investigators are in India and China investigating our facilities. So this explosive growth in FDA inspections in India and China across the generic drug manufacturing facilities has been funded by our own money. We gave the FDA our money and they used it to buy the investigators' plane tickets to India.
Correct. Yeah. So we have three scenarios here: compliance, regulatory challenges, and then catching with the regulatory challenges, compliance level, and governance. I think governance, I have deliberately not touched upon in detail because in the previous sessions, a lot has been discussed about governance, independent director's role in this government governance framework and all this area. So what are the time left out from this session? I would throw this.
Add one thing.
Sure.
I think one most important part, if you are advising a consumer startup industry, which relies very heavily on the Google Play Store, Apple Play Store, and Facebook, LinkedIn's of the world, then your mindset for compliance, one is more about the compliance of laws, which are like statute books, right? Second part is also the compliance of how your business or your app or your business model is complying with the terms and conditions of the Google Play Store. Because like what we say that our laws are ambiguous, trust me, I mean, I spent almost 20% of my time interpreting the Google Play Store terms and conditions or Facebook terms, YouTube terms, iOS terms. They are as ambiguous as any other Indian law. So I think when you talk about compliances in a disruptive industry, depending more about third-party ecosystem, you need to also pay extreme importance, I would say more importance than what you would be paying to comply with statutory rules to all the terms and conditions of these ecosystem. Just imagine that, you have launched an app which has got 100 million downloads and, you have maybe, let's say, more than 50 million monthly active users coming out of your Google App Store as well as your app on iOS. And suddenly, because of some oversight of any change in the terms and conditions of their app, they put your app down. Your valuation, what we talk about, multi-billion-dollar valuations, will not drop by 35% like what it happens in pharma. You will be vanished. You will be vanished. You would be thrown out of the investor community. And you haven't violated the Companies Act. You haven't violated any FEMA law and all. You have only violated some terms of the App Store, and you are just screwed, right? Similarly, nowadays we build so many innovative business model, taking the APIs from YouTubes of the world, taking the APIs from Facebook. Most of the sites or the blogs where we go and get ourselves registered, they say that log in through Facebook, log in through LinkedIn, log in through Gmail, right? So you have your entire database of the users who are logging in through their various social media account. If you fail to comply with that, your entire site is down, right? So very important if you are working in a consumer internet industry, depending a hell lot of on all these third-party app stores and login mechanism, APIs, you must make sure that more than the Indian statute, these terms and conditions are your real Bible. Otherwise, you will be vanished in no time. And Google, if you have to appeal against their decisions, your investors will just fly away. So
And
that's something which I think one should keep in mind.
And just
So
take
last
on from his
from
point.
Santanu now, and then we can
Sorry.
throw these sessions to the audience for question answers.
Absolutely. No, I just wanted to pick up from what Ashish was saying, and statutory compliance bleeds into contractual provisions in the pharmaceutical industry as well, because all of these provisions on what constitutes ethical business promotion will find their way into pages and pages and annexes in any in-licensing agreement or in any supply and distribution agreement with any American company. They will have pages which detail at the most microscopic level how much you can spend on an event that is classified as a learning event for medical education event, or whether it is a promotion event. If it's a promotion event, then the event then you can't spend more than a certain amount. It cannot be unnecessarily lavish. You can't fly in doctors from beyond. You can't fly doctors if it's for a drug that's being sold in India. Then you can't fly doctors overseas. And these are all things that are written in annexures in these agreements when you enter into them.
So try to become a business partner who enables a business to comply with the law, whether it is internal policy, business requirement, or external regulatory changes. Before some things become must for you, you prepare yourself and try to understand the business. So the role of the GC or compliance officer is more of a business partner rather than typical hardcore lawyer who reads the provisions and gives the interpretation. That doesn't work in organizations, at least where I worked, number one. And number two, try to convince to your business community or your internal clients that compliance is an investment and compliance is not cost. With this, I would like to conclude these things and more from audience, what is their experience about compliances and when you try to raise this question, please try to ask very macro level generic questions so that more other audience will benefit out of your question answers rather than asking legal technical questions. Please.
Current times, because a company like Novartis has been denied a patent in India. Corex from Pfizer is facing sanctions from the court, whereas generic makers from DV's lab to Sun Pharma to Lupin to DRL, suddenly every generic manufacturing pharmaceutical company is getting 483 Form 483 observations. So is there some uneasy calm that you see in the current times?
Should I? So yeah, absolutely. And I think the friction is at multiple levels. So first, let's talk about, I think I touched upon this earlier, about Indian generic companies doing business in the US. Now, obviously, they provide a cost-effective competition to US generic companies. They also provide competition to US innovator companies. Both the US generic companies and the US innovator companies have substantial influence within the FDA. So that to us, I mean, you know, the FDA has its hands deep in the pockets of both sides of the aisle, right? And that's just the way it is, right? That's just the way the world works. So although the US generic industry and the US innovator industry may be at odds with each other within their territory, they are united in their desire to see Indian and Chinese generic competition within the US be scaled back. That explains to a certain extent the increased scrutiny upon our manufacturing facilities, EIRs, Form 483s, all of that stuff. The second level is that of patents not being granted, evergreening challenges, biosimilars being pulled up in the courts. That is simple. That's a function of how in India we have traditionally been less receptive to a strong IP regime. You must remember that it wasn't until 2005, was it, Ranveer, that we got product patents? 2005, we didn't allow these guys, Novartis, etc., to have their products patented in India. So you're starting from that position. So obviously the IP regime is much weaker. And secondly, it's very interesting actually, because you'll find the same companies that are competing with Novartis and Eli Lilly in the generic space also in licensing patented products from those same companies. The same companies. So you've got a company that's filing suit to challenge, a Roche oncology product before the courts. At the same time, they're trying to in-license another oncology product that they know they can't successfully duplicate in India. So that's just the nature of business. It's people understand that you fight the battle at different levels. It's not necessarily an East versus West thing. I think it's just business. That's just the way it plays out. Having said that, of course, there is a clear sort of divergence of interest between innovator companies and generic companies. Ranveer?
Yeah. No, thanks. So I liked the fact that you use the expression uneasy calm. As long as the relationship is calm in some way or form, it's good. But uneasy, yes, look, I think, it's always been a debate. There are certain conversations, so that Novartis example which you gave, so Novartis, they had a big fight regarding one of their product patents, and when they lost before the Supreme Court, all of a sudden, India was blamed for not being very strong in IP. And that's when you saw a very strong reaction from the patent authorities and the government as well, saying, well, we have rejected one patent of Novartis, but no one is talking about the other, say, 50 or 60 odd patents which we have granted. And no one is talking about the other patents and the process patents which we have granted other pharmaceutical companies. So these conversations take different complexions at different points in time. With regard to, again, the relationship between the US FDA and India, look, again, there are many theories. Some people will say, is the new administration trying to draw more manufacturing internally, and therefore they're driving up the requirements? But then, there's another school of thought also which says if the requirements apply to US companies, the same requirements would apply to Indian companies as well. So I think it's a journey for Indian companies, whether it be in the IT space, pharma space, to keep up to those expectations.
Novartis case was more of a balancing exercise of the government in the public interest as well, to some extent.
Absolutely, absolutely.
But you could make that argument for all drugs. See, that's the problem. Public interest is a very slippery slope. You
See,
can make that argument for any drug.
See, with respect to public interest, I remember there was this case of Bayer versus Natco. Another example where Bayer had a cancer product, and they were not being able to sort of commercialize that product to its full utility. And here you have a generic company coming to a court and saying, well, look, you've got this fantastic drug, make it available, and I can make it available. Now, these debates will go on forever. I think it's very interesting. The innovator companies will always say, I'm spending billions and billions of pounds investing in a drug. And the generic companies will always say, well, it costs 1.5 lakh per tablet, so I can make it cheaper. So it's an interesting conversation, as long as it remains calm.
Industry also, and same goes with Ashish, because innovation is a requirement everywhere. Now, do you think extra compliance kills the innovation and stops the mind to think about innovation? And how difficult it is as a legal head in particular industry, how you deal with it?
So your question reminds me of a very viral Facebook and WhatsApp kind of forward, which was a short statement made by Mr. Rajiv Bajaj, who is the CEO of Bajaj Group in the World Economic Forum, and I'm sure many of us would have laughed on that video. He said that if in India, if your innovation depends upon regulators and interpretation of the court, right? So his, talk was on in terms of Make in India and innovation to happen in Make in India. So he said that that's not Make in India, that's Mad in India, right? So if you ask me, I think my personal experience is that innovations will always precede development of the compliance ecosystem, right? I think the good part, as per my experience goes, irrespective of whatever government, whether this government or the previous government, right? I have lobbied before both. I think they are extremely open-minded, extremely open-minded to address the compliance need or regulatory needs of the innovative industry. If it basically benefits the industry, it creates job, it alleviates poverty, and it helps them to secure their vote banks, right? I think my co-speakers have alluded to the fact that it's not about the compliance ecosystem alone, it's the interpretation of the compliance ecosystem, right? Unfortunately, with all due respect to our judiciary, we have some part of judiciary which has recently made a statement that the tears of peacock can really, do some wonders, right? Mm-hmm. So I think that where, as per my understanding, that's the dark hole of the compliance system and deterrence of the innovation in India, how the old man sitting on the other side of the courtroom thinks about your business versus the compliance. Otherwise, I think the entire ecosystem is perfectly set. That's my personal experience.
If I can just jump in, at a more philosophical level, innovation is politicized, in the sense that there's a theory of intellectual property that fundamentally says that intellectual property serves to propagate the differences between the first world and between the developed world and the emerging economies. Because the emerging economies simply don't have the cash in their pockets to invest in innovation. Now, I'm not talking about technology. Obviously the app landscape has changed everything, but because you don't need capital to innovate anymore. But leaving that aside, certainly in our industries, in pharmaceutical, you need capital, and you need lots of capital to meaningfully innovate. And add to that the problem that you're seeing the theory of diminishing returns in pharmaceutical R&D. So with every successive year, the large innovator companies derive progressively lesser returns from their R&D efforts. Large pharmaceutical companies are no longer seeing the kind of drug approvals, new drug approvals that they used to once. Now, the innovation is happening with small companies in campuses in Silicon Valley or in Boston. They're happening with startups in garages. And there's a theory that, once a company gets to a certain size, it stifles innovation by its very nature. So innovation is not as straightforward as that. I mean, we can talk about a large number of things, but at a certain level, it will always be seen as, rich countries innovate and poor countries can't afford to. So we need to scale back on the kind of protection that rich countries are afforded their IP in our country, which is a poor country. That's why we didn't have IP.
Add on the investment part, sorry, interrupting. Just one homework for everybody, right? Just see that how much investment was made in Amazon or Google before they went IPO and they actually became a great innovator, and how much investment has been pumped into Indian your consumer internet system. I think the investment which I'm talking about my industry, investment which has happened in India is 10 times more than what has happened in the US for those companies to reach to the level of innovation. I don't think there's a lack of capital availability in India for innovation. It's just the lack of culture.
No, that was marketing investment, right? That was investment to grow market share in India. I'm talking about sort of stuff that you can patent. So innovation from that perspective, I guess. But yeah, sorry, go ahead, Kanaya.
So what is the return of ROI on investment, and the differential factor is IP recognition in country. That's what I'm getting. Anyway, that's it, I think. No question answers.
Kavita had threatened to ask questions.
Okay. So with this, I think I'll thanks my co